Paul. Yes. Senate reports noted that reasonableness must be judged by the circumstances of an individual case. And in the view of one commentator, timely notice would require that the defendant be informed enough in advance of a public proceeding to be able reasonably to organize his or her affairs to attend. Now, I know as a respondent of a lot of court hearings, yes, this reasonable, accurate, and timely is important. The United States versus Turner, provides vital flexibility. Accurate may well impose an affirmative obligation, yes, to advise victims of schedule changes. Most states have similar statutory requirements, and timely is designed to be a flexible concept that ensures a respondent can reasonably arrange her affairs or to attend the proceeding for which notice is given. Yes. Then there's the United States versus Ingrazia, describing online victim notification system considered inadequate that provided outdated scheduling information. Oh, boy, they really go into it about this reasonable, accurate, and timely. Yes, I really like it because every time I told you, I did not get notice or the opportunity to be heard. Ouch. There was no reasonable. United States versus Turner. Oh. Now, it says here when it became apparent that the alleged victim had not been given specific notice of the first two proceedings. Yeah. I considered an adjournment as an alternative to further proceeding in violation of the victim's rights. Another alternative, and one that I concluded was preferable under the circumstances, was to order the government to provide a written summary or transcript of the proceedings to any victim who was denied notice, and to make it clear that I would hear any victim with respect to whether the decision I made, the victim's absence, should be reconsidered. Pooch. Now, so it looks like a judge, yes, had realized that a victim or victims had not been given reasonable, adequate, and timely notice of court hearings, and decided, well, maybe I should reconsider the decision. Now, as the respondent of temporary and permanent protection orders, yes, I was not given reasonable, accurate, and timely notice of court hearings. And then as the respondent to a dissolution of marriage, yes, I was not given reasonable, accurate, and timely notice of dissolution of marriage proceedings. Yes. And then when you arrested me for the allegation of violating the protection order, 24 days after it happened, yes. Was it reasonable, timely? Well, the probable cause arrest on January 4th, where I wasn't in Sequim, Washington. Was it accurate of you to have me put in jail for a crime I didn't commit in a city I wasn't in? What about that 2-count criminal complaint where you waited until August 2nd to file the 2-count criminal complaint for the allegation of domestic violence on June 16th of 2017, approximately 7 weeks later? And then you said, well, we actually did arraign me within 14 days of the August 8th filing of it. But you signed it, and dated it the 2nd of August. Now, I'm thinking that reasonable, timely, and accurate hasn't been a priority of the judicial system of the United States of America. And when I informed you of my clearly established rights, and you said, we're not going to enforce the sheriff's manual, we're not going to enforce the RCWs, we're not going to enforce any constitution in any state, we're not going to enforce the United States Constitution, we're not going to enforce the federal legislation issued in accordance with the requirements of the VAWA to protect the due process rights of the respondent. And we're not going to enforce the DC code, the actual District of Columbia's code. We're not going to enforce the United States code. You know, as the respondent, When you issued a temporary protection order in 2011, yes, it was not reasonable, yes, timely, and adequate notice of court hearings before you gave custody of my sons to my wife, yes. You can't just issue court orders and then decide to serve me on Guam. Oh. Now I'm going to want my sons today, do you understand? And